Hallo, ich wollte noch mal melden. Ist alles in Ordnung? Können Sie mich hören? Hallo? Das mache ich gerne. Gucken, dass wir noch mal ich mache mal den
Good morning, everybody. Good afternoon, good evening, wherever you are. Welcome Good morning, everybody. Good afternoon, good evening, wherever you are. Welcome to ECCHR event series, Human Rights in Times of Crisis, of Resistance and Concrete Utopias. This event was actually planned back in 2019 together with our cooperation partner, the Federal Agency for Civic Education, obviously as an event in presence together with workshops, because even by that time we were aware that we as human rights organizations are facing a multiple and very complex global crisis, climate crisis, crisis of water, of food, growing authoritarianism, which requires a new discussion with new actors, with other actors than the very close human rights community. And obviously, with the current pandemic crisis, it became even clearer that the conversation is needed. We're hoping that at some point in the upcoming months, we will be able to fulfill our function as ECCHR to serve as a platform, as a hub for actors beyond Germany, beyond Europe, beyond law, an interdisciplinary mixed coalition of people. But as Alejandra Ancheta from Mexico said, we have to maintain our internationalist spirit, and so we have to bridge until this time has come. And so this is why we decided to aggregate one more online conference series to the endless series we're having already.
I want to introduce you today to our second discussion round. This time the topic is corporate power, the role of law, and human rights. Let me introduce you the speakers of today's session. We have with us today Katharina Pistor, who is a scholar, writer, and a writer on corporate governance, money and finance, property rights, and comparative law. And she's a director of the Center on Global Legal Transformation at Columbia Law School. We also have with us from Mexico, Guillermo Torres, who is a senior lawyer at ProDESC, a Mexican human rights NGO, where he works with rural and indigenous communities, as well as with groups of workers in the search of justice, corporate accountability, and the enjoyment of economic, social, and cultural rights. With us here in the studio in Berlin, we have Johan Horst, who is a German legal scholar and currently a postdoc student at the Integrated Research Institute, Law and Society at the Law School of Humboldt-University here in Berlin. Today we will explore how law is an important factor in creating corporate power. And we will discuss the legal and political options to restrict this dynamic of growing corporate wealth and influence. Can human rights, especially economic and social rights, play a role in ensuring our societies become more equitable? We will start by having Katharina present her main thoughts that she developed in her recent book, The Code of Capital. In this book, she examines how assets such as land, private debt, or in business organizations are transformed into capital through law. After this, we will enter into a discussion with our other panelists, and of course also with you, the audience, and we are very much welcoming you to put forward your questions in the chat function. So Katharina, I'm very pleased you have taken the time to be with us today, and the floor is yours.
Well, thank you so much for the kind invitation and for having me. It's really a great pleasure for me to be with you and also to explain to a human rights audience the importance of law. The Code of Capital is really an attempt to look in the underbelly of the capitalist system, to look at the genetic coding of capital, if you wish. So I use the term code not in the German or civil law tradition of codification, but in the sense of coding, like genetic coding or software coding, if you wish. So I'm basically making a very simple argument in the book, which is to say, give me any object, any promise to future payments or any idea, and I can flip it into a capital or wealth generating asset with the right legal coding. What this new capital asset has to have are at least 3 of 4 attributes. The holder of the asset must have priority rights over others. So some have stronger rights, others have weaker rights. The rights must be durable so that wealth can incubate over time, and must be protected so that it does not fall prey to the next financial crisis or other circumstances. It must have universally enforceable rights. So everybody has to yield when these rights have been created and recognized. And last but not least, for financial assets in particular, we need convertibility, which is not just transferability or tradability, but the option to convert my current asset into something safer on demand if I can. So why is law so important? My argument that law is so important stems from the fact that our capitalist systems are scaled systems. They're large, they're complex. And what they need to ensure that everybody abides by the principles of somebody has stronger rights, somebody has weaker rights, we can make interests durable, or we can make them universally enforceable, is the threat of enforceability. And that's basically what the state does. Centralized state power is basically institutionalized as law, and not only as regulatory law or criminal law or even human rights law, but as private law. And that's the focus of my book. So when you think about the various dimensions of law, we can think of vertical dimensions between the state and its citizens or other people, or between the citizens and the states. Human rights, civil and political rights are vertical rights that individuals can mount against the state. What I'm interested in is the way in which citizens organize their economic and social relations with one another by taking recourse, by availing themselves essentially of state law. So the core argument is, even in these private relations, which are often characterized as free and market-driven, law is central. In the book, I walk my readers through this argument by showing how land has been coded, how firms have been coded, how debt has been coded, how know-how or ideas have been coded in law. And I introduce them to 6 different legal modules. They have done most of the work. Other legal modules can do similar things, but for the last 400 or 500 years, we have actually seen that they do quite a bit of the work in coding different assets as capital: contract law, property law, collateral law, trust law, corporate law, bankruptcy law. Now, I know that we are particularly interested in corporate law today, and so I'm focusing on this one aspect, on cloning legal persons. The corporation, the limited liability company, or the publicly traded corporation are legal persons, and that's a creature of the law. That's what the name says. But it's important to realize that it's there and has major ramifications for how we organize economic relations. Economists sometimes say this is a legal fiction, but it's no fiction at all, because we create a person that can own its own assets, can contract in its own name, can sue and be sued in its own name. And it can confer, and does confer, as a matter of law, limited liability to the shareholders that are often called its owners. It has durability. Why durability? Because it can live forever. Early corporate statutes gave a corporation a lifeline of maybe 10 years, maybe 20 years. But nowadays you create a corporation forever, as long as it can balance its liabilities with its assets, as long as it doesn't go into bankruptcy, it will survive. So you have to put a legal person actively to death. It does not die a natural death. Universality is also built into this, because the principles that are set forth in the law will be recognized, have to be recognized by everybody else. Otherwise, they can go to court, or they can make complaints, or they can say they're not bound by a contract. So we enforce these principles in general, and not only, and that's important, in a single legal order, not only in the legal order in which the legal person was created as a matter of law, but we've come to a point where legal persons are recognized by almost every other state, as long as they comply with the rules in the jurisdiction they chose for their place of incorporation. I will say a few more words about the incorporation versus the seat theory in a second. So in the book, I'm not going to go through the details here, but in the book, I'm talking about Lehman Brothers. And I'm showing here that the corporation actually is no longer just this legal vessel that we use to engage in industrialization, to raise capital and to invest and to hire labor, et cetera, et cetera. But the corporate form, with the specific features that I just discussed, priority, durability, universality, and also some convertibility, I will drop this for now because I don't have so much time, but how we use this form actually to create massive corporate empires. Here, Lehman Brothers, which was easy to dissect because it went under in 2008. And so you can do what I like to call an institutional autopsy. You can dissect what happened before. And Lehman Brothers consisted of more than 200 registered subsidiaries, hundreds of more of other legal entities, sometimes trusts, sometimes corporate entities, which were used to manage the relationship between different assets, new financial innovation, and their creditors and the ultimate shareholders of the parent company, Lehman Brothers Holding. So they raised capital cheaply on international lending markets. They channeled all the profits back to the holding company and they paid it out to their shareholders. And these were the ones that really then benefited the most. Some people say, you know, they were surprised that Lehman would ever go under because the shareholders should have prevented them from doing so. But the shareholders had enriched themselves long before Lehman ultimately went under. So just a few more words. I don't want to speak too long, but a few more words about the question of the corporation in the global world, because that's the situation we're facing. There's always been a competition between two principles of choice of law, or conflict of law rules, as we call them. International private law is the term we use in continental Europe, which means is under what conditions does a legal order recognize a legal person from a different legal order? One principle has always said we do this when you abide by the rules of the place of incorporation that you chose. Another rule has said you have to be incorporated in my jurisdiction if you do most of your business in my jurisdiction, if you have your seat here. That used to be the old German rule, which also has been weakened and undermined by European Union integration and the interpretation of the European Court of Justice. But I just want to mention these type of rules because they will explain why we actually can have a global capitalist system, even though we don't have global property law, global corporate law, global contract law, global bankruptcy law. We have domestic laws that furnish the cloth from which we cut capital, not only domestically, but globally. And this works through these choice of law mechanisms. So if you can choose the legal system by which you want to have your legal person governed, or the assets that the person issues governed, or your contracts governed, then you can treat the jurisdictions of countries around the globe as a menu, like in a restaurant, from which you can choose how to code capital. And that's basically what has been happening for more aggressively over the last couple of decades, but has been happening for quite some time. So the most important source code for global capital from many corporations that are around, most financial assets that are around, are English law and the law of the United States, specifically the law of the state of New York and Delaware. And that's also, of course, in London and New York is where you have most of your highly paid lawyers sitting, not only the financial institutions, but of course the lawyers. And the fundamental tension that comes about when you think through the system, how it has been stitched together at a global level, is of course how we can square a system where some can pick and choose the rules by which they wish to be governed with our fundamental ideas of democratic self-governance of we the people. But let me stop here, and I'm looking forward to our discussion and to questions later on.
Thank you, Katharina, for your presentation. And of course, thank you for your book, which I think is really a very valuable description for everyone who's interested in this topic, but also, as you said, I think for human rights lawyers engaged in the field of what people call sometimes business and human rights. Because you're very, very precisely describing, I think, some of the reasons of what those that are trying to defend the rights of those that are not on the side of capital, the difficulties we are facing. So you also call it at some point it's an uphill battle, and I had to smile a little bit when I read this again, because I thought, like, yeah, I think that's what probably Guillermo and many other of our colleagues are constantly saying. It's really an uphill battle, and I'm very grateful that you're demonstrating sort of also the very practical hurdles that there are. I think you mentioned at some point also statute of limitations, the burden of proof, costs of proceedings, that all do not play in favor of those that cannot necessarily pick and choose the jurisdictions and the applicable law they would want to, their case to be governed by. And I think I do hope that we can, you know, while we are speaking now, we can elaborate a bit more and think about more, but what are the options of how we can deal with this system and the legal system as it is. So we will hear more from Guillermo and his experience as a lawyer working in Mexico, but also working transnationally. But I also want to take the time, even though I'm the moderator, to explain a bit of how we at ECCHR have been trying to sort of grapple with exactly this, the problems that you so skillfully and much better can explain than we can explain. And I think sort of I would say that there are two main issues that we have been trying to work on, and that is this question of what is sometimes called parent-subsidiary liability. So we've been not being located or mostly working in a continental European legal order, so we have been trying to use criminal law, both national criminal law but also international criminal law. And we've been using the concept of complicity or aiding and abetting, for example, international crimes, to hold companies to account for human rights violations that was committed by their local management in a country other than their headquarters. For example, in the Lafarge case, we are engaged with the other French organization Sherpa in a case against the French-Swiss cement multinational. And we are representing former employees from Syria in a criminal trial that is currently ongoing in France against the top management of Lafarge in Paris, and against the legal entity as such. And in this case, is currently before the French Supreme Court, and the indictment is on the charges of financing of terrorism, but also for complicity in crimes against humanity as its subsidiary, the Syrian subsidiary, wired in an alleged 13 million euros to ISIS while trying to keep the operations going in Syria when the civil war started to evolve. And the evidence there clearly shows that despite the legal theory that headquarters is completely a separate legal entity from the Syrian subsidiary, we're lucky to show that headquarters is very much involved in its subsidiary's business. Another topic that we've been dealing and working with, I'm also personally been very involved, is the question of supply chain liability. And there we've been working with trade unions and labor activists from South Asia, and specifically from Pakistan, to engage in civil litigation in Germany against a German textile retailer called KIK. And we've been trying to make the argument that under the tort of negligence, which is the applicable law in Pakistan, it's a common law country, we've been saying under the tort of negligence, we can argue that the retailer KIK had a duty of care that it owed to the workers of the factory that in a tragic fire incident died or were seriously injured. And again so we're trying to argue for criteria of proximity and influence, that we actually want to create a liability that that sort of the mere contract law, the contract between KIK and its retailer on so and so many jeans that are supposed to be delivered, obviously doesn't foresee. And so I think that's one of the ways of we've been trying to overcome some of the hurdles by way not all that you are naming. But so Guillermo, we want to come to you now and hear about your work and how you mobilize the rights of indigenous groups against corporate actors.
Thank you, Miriam. First of all, I want to thank the ECCHR for inviting us to be part of this very interesting panel. Very excited to share with all of you. And regarding to your question, I would say that it's been a learning and awareness process, because first we had to realize state actors were not the only obstacle or the only responsible for advancing socioeconomic and cultural rights in Mexico, but corporations also had a lot to do with it. So even though this is now a common idea in human rights litigation, but when ProDESC and its founder Alejandra Ancheita started to litigate cases regarding socioeconomic rights 20 years ago in Mexico, that was not like the mainstream idea. So when we started working in Mexico, litigating cases in Mexico involving human rights violations, we soon realized that in every case we litigated, there was a corporation implicated. So whether it was migrant workers going to the US under the H-2A visas charged with illegal fees by recruiters in Mexico, or in a collective bargaining case in Guerrero involving indigenous communities who suffer from violence and harassment for standing up for their rights, or an agrarian community in northern Mexico affected by leasing contracts regarding the use of their lands, or more recently, in a consultation process related to a wind power project that was or is being improperly conducted. There is always a company behind. So if we, as human rights lawyers, thought that we were to even think of the possibility of achieving change for affected communities, we needed to have corporations on the radar and hold them accountable through legal means. So that is how we started mobilizing not only rights of indigenous peoples, but also those of workers, those of women or agrarian communities. And we do it with a clear idea in mind, which is, of course, advancing in the enjoyment of the rights, but also preventing severe human rights violations. So in that regard, we have targeted not only state actors responsible for human rights violations, but also private actors that are involved or behind the projects or the cases where human rights violations occur. But also targeting, as you was mentioning, Miriam, the supply chain. So, for example, in one of the cases, we are accompanying migrant workers in Sinaloa. We have developed a strategy to address not only human rights violation caused during the recruitment process in Mexico, and by bringing to justice recruiters who charge illegal fees to migrant workers that want to go to the USA, but also to create evidence in order to hold accountable the company that benefits from those violations that occur in Mexico. And we have been successful so far in that regard, but we have to consider that we don't just necessarily want to stop this kind of violations, but rather prevention is on the core of our litigations in order to level the field in which the cases are unfolding, but also to secure that monetary compensation is the only remedy we could provide to affected people, but rather guaranteeing that communities and collectives actually enjoy their rights. Because otherwise we would be legitimizing the idea that any violation can happen or can take place, whether in Mexico or in the global south or in the global north, and companies can go away with it with just giving monetary compensation. So the idea behind of our idea of mobilizing socioeconomic rights is prevention. And even though litigation is a key element of our methodology, for us, it is only an excuse for organizing. We believe that organized communities are stronger and more powerful than any legal case we might win. We organize communities by developing or increasing their abilities and their capacities to stand up for their rights, by also raising awareness and recover historical memory. So I would say this in general is how we think on the ways we can use law against corporate actors. I can go further on that maybe later. But yeah, this is basically the main idea.
Thank you, Guillermo. I think, yeah, now we want to hear from Johan. Johan, you have done research into the question of how transnational law, the transnational law of financial markets, is generated, and you've looked at, taking concepts of legal pluralism, and you've analyzed the role of the different actors in generating norms, and you've also looked into the role or the momentum that human rights arguments can create in that field. So please explain us more about your work, and also how it probably connects to Katharina's.
Yeah, thank you very much. I'm very happy to be here. And this is also because my research is very much inspired by Katharina Pistor's work. In fact, in 2014, I took part in a winter school on law and finance conducted by Katharina Pistor. So happy to see you again. I think in particular, I share Katharina Pistor's critique of a set of economic beliefs that have shaped the mainstream view on the relationship of law and economic processes, and also on the distinction of public and private. Much of my work is dedicated to better understand the constitutive role of law for the economy and processes of accumulation of capital. And as you mentioned, I'm in particular interested in forms of norm creation and law beyond national polities, that is transnational law. I think law creation by private actors and in hybrid settings plays an important role in what Katharina Pistor just explained in her notion of capital and coding of capital. A well-known example, I think, is the legal infrastructure of the OTC derivatives markets, which is shaped to a large extent by a private organization called the ISDA. Now, these markets exert massive effects on society in general. Scholars have, for example, argued that these markets have contributed to the recent food price crisis. They have argued that activities on these markets can affect costs of sovereign financing, of sovereign refinancing. And it is argued also that the OTC markets had a big role in the financial crisis of 2007 and 2008. And Lehman Brothers is, if I'm not mistaken, an example for this. Now, with legal pluralist theories, I share the belief that the role of the state, or to put it more broadly, the concept of self-government of a polity, does no longer suffice to repoliticize or redemocratize these types of hybrid legal infrastructures. We cannot rely on parliaments, national parliaments alone, to democratize transnational rulemaking. And I think this is why we need to explore alternative or complementary avenues for democratizing. And my interest in human rights has very much to do with this pluralist notion of democracy. I'm interested in finding out whether and to what extent human rights can really play a role here. Now, as Alejandro already mentioned, we know that several of the actors involved in transnational rulemaking are so-called private entities, right? And we also know that a good part of the negative effects on human rights are caused by private entities. In my research, I'm therefore primarily interested in how human rights can serve to address these effects of private corporate power. And I think this is at the core, this is also the core question we are dealing with today, and I'm happy to hear more from you. Thanks.
Thank you. Yes, Yeah, I think we've now touched on two really the two things I want to discuss with us today, and that is one, the question of how can we influence the creation of norms, of probably better norms, or at least how can we influence the fact that norms are constantly created by private actors, by economic private actors. But before that, I think I want to be a bit more specific on this question of, and I think sort of then the question is, norm creation can be influenced traditionally through democratic processes. We can say we need law reforms, and I think, Katharina, you also, and later on you should elaborate a bit, sort of what could be changed in law. But then also I think, and at least that's what Guillermo and ProDESC and also ECCHR and others are doing, we also think we want to use the law as it is now. And of course, by that, using it in court through litigation, we hope to change something, no? And that's okay. And then we don't need to go into this literature, what does it change? But I think I still want us to grapple with this. And Katharina, because you are saying at some point, you also analyze some litigation in your book, and then you say that elevating new claims by bestowing on them legal protection does not change the system, it only reproduces it. I think you say that in relation to, you also, at the same time, another aspect that I found very interesting, that you're also saying that legislation is necessarily always abstract and incomplete, and therefore it leaves room for creativity. And you describe how corporate lawyers are using this in the interest of their corporate clients. And then you, as I said, my impression is that you're quite skeptical that there's any way of changing the legal system that we have now through cases, through litigation. And I'm wondering, is that so? What's your opinion? And is there not room for creativity also for the other side? I think that's sort of from the side, from below.
Yeah, no, absolutely. Let me just clarify. So I do think that just single cases alone will not change the system. They never do. But I think incremental change happens mostly through small steps. And in the final chapter of my book, I discuss different options that we might have. I don't really believe in the possibility of a radical reform short of a massive crisis where we really start maybe from scratch, although one never really starts from scratch. But I think incremental, very strategic incremental interventions are important. So I do, I would agree with you, first of all, that creativity can come from both sides, that the law is always incomplete and therefore leaves that room necessarily soon. Also, it's a good thing that it does. I mean, because that's how we can organize communities of different kinds, with different purposes, with different goals. And we want that freedom without necessarily losing the ability to also get some legal backing for the kind of arrangements that we've made. So in that sense, I don't think this is all bad. The point is more that I think over time there's been a certain bias built into the system that has favored those who had the resources to use the system in a particular way and have coded in a particular way. What we see now is that very often the most resourceful player no longer go to courts unless they have to. If you sue them, then they have to. They don't have a choice, right? They can try to wiggle out somehow, but if they don't have to, they might want to prefer a private settlement or arbitration and use the state legal system only to execute, to finally enforce the rights that they were able to defend. So you see sort of they withdraw from that because there's a danger in a judge maybe using the judge's own discretion, some room for interpretation to counter the arguments that they make and to throw out maybe an entire contractual framework that they have developed. So I think so if you run after them in court, I think it's that's one of the battlefields that we have to use. But what I want to say is that it's at the same time they're also moving away from it and using other ways to resolve their own disputes amongst each other and set the norms for the rest of us. So it's a dynamic field. It's a continuous struggle, and I think we just have to be aware of that, which is why we might need some more interventions. There could be better standing for more groups to bring the kind of actions that you're talking about. There could mean less protection in the form of limited liability for parents vis-a-vis vis-a-vis their subsidiaries, but maybe also for ultimate investors, for companies that engage in human rights abuse or engage in massive pollution. So I think there are lots of possibilities where we could intervene. Some will require legislative interventions, others can be battled in the courthouse, and yet others will have to be fought out, I think, through social mobilization, new forms of business organizations and the like.
Thank you. Johan, how do you see the role of human rights in changing, or human rights arguments brought forth in changing social and economic realities?
Well, I think I share much of the skepticism of a strictly individual rights-based approach. And I think the evolution of IP law is a good example of what the problem here is. A rights-based approach, he would, for example, consist in assigning IP rights, for example, to individuals of an indigenous community. Yet I think this is not the problem here, what the people want to address. The problem does not consist in assigning property rights to enable a community to take part in a capitalist mode of production, for example. Rather, in these cases, the problem is deeper. I mean, the problem is that these communities want the right, so to speak, not to having to take part in capitalist modes of economic exchange. They want a different form of economic exchange. And this, of course, is a demand, I think, which is hard to formulate within the existing framework of individual rights. So that's my skepticism. Nevertheless, I also think there might be some hope for or some potential of human rights. I think if we look at the debates of human rights in global value chains, on human rights in non-financial reporting, on human rights in climate litigation more recently, on human rights and the issue of food prices volatility, I think all of these debates have one thing in common. The role of human rights, the role human rights play in these new settings cannot be sufficiently grasped by focusing alone on a traditional notion of individual rights, right? So to give an example, in the recent Agenda case in the Netherlands, the court based its reasoning on Article 2, right to life, and Article 8, right to respect for private and family life, of the European Convention on Human Rights. However, it is obvious that this case is not about an individual claim of a specific person. It was a class action, actually. It's about the society-wide structural problem of climate change. And I think this is also clear in the recent order of 24 March 2021 of the German Federal Constitutional Court. In its decision, the court refers to the need of an ecological transformation several times. I think another example is the role of human rights with respect to non-financial reporting. Here again, the role of human rights does not consist in giving a specific person a specific claim against a specific state or specific corporation. In this sense, these are weak instruments. What they do, however, is that they make adverse human rights effects of a corporation's activity an issue of corporate governance. And this is not without merit, I think. For example, in Germany, this means that certain instruments in securities law and capital markets law can now potentially be used to enforce non-financial reporting obligations with respect to human rights. Here, certain administrative fines may be applicable, and certain shareholder resolutions can be appealed if the non-financial restatement is incorrect. Non-financial reporting, so to speak, is a tool to politicize corporate governance. And we have just seen that oil companies such as Chevron and also ExxonMobil are actually under pressure now by shareholders to decarbonize, for example, their corporate activities. Though I think we can also kind of witness a shift in the doctrinal use of human rights arguments by courts and also by the legislature. And this, I think, I'm not sure if this is the best way of addressing these problems. I'm not sure about this, but at least it's a new development which has some potential, I think.
Guillermo, I'm sure you're not naive about the role of courts and the chances of plaintiffs to win cases against corporate interests. But why do you still believe in using the courts, and why do you also engage in transnational litigation?
Well, I think it's basically the core question, but also it might be a tricky one. But I would like to start by acknowledging, as Professor Pistor mentions, that state is still a key element for enforcing this law under economic globalization. But taking that into consideration, I think I would, or we would identify two sets of considerations. First, one theoretical, political set of considerations that, of course, we acknowledge law is a field of disputes, of battles for power, where certainly economic actors have, or are in the top, have actually the power to create, to enforce law. But since we also consider a state is still relevant in this globalization phenomena, hence courts are still important in order to continue capital accumulation, but also to challenge the way law is created and is being applied in practice. So we believe there is a counter-hegemonic way to address law and also human rights. And I think it's through the lens of affected community that is in a critical collective way. And I think social movements also believe that law is on their side, is created in order to protect them, to secure the enjoyment of human rights or their basic, or to cover their basic needs, because they, and we assume, a state should be driven by the idea of securing equity and justice to everyone. So this might not be a descriptive approach or perspective, but rather a prescriptive one, but it is a good reason to fuel our resistance before court. And that brings us to the second set of considerations, which is basically the practical considerations. So if we leave aside the law as a battlefield, then what other options do we have? Or what other options we as human rights NGOs or as lawyers can offer affected communities? We can offer them to do nothing and leave it all in the hand of economic elites or through violent means. I don't think none of them are the right answers, because in the current context, we believe that no life should be offered in exchange of advancing rights. We have mechanisms, we have institutions, we have networks that should prevent us to get to that point. Of course, there's like this tricky part on how we use law in a way that could actually provide remedy and provide change for affected communities. But I think we have been successful so far in this. For example, in Mexico, we have this case that we're actually litigating with you in France, of an indigenous community in Unión Hidalgo, where we were able to suspend a 300 million wind power project from being installed or developed in violation of human rights of Unión Hidalgo indigenous community. And in addition, we have used this case in order to challenge the system and the normative framework that was created in 2003 and 13 by the past administration, and which opened up the market of electricity in the benefit of economic actors. Of course, this is a case still ongoing. We have not reached any result, but I think for an affected community that has already a wind power project operating in their community, and which was not subject to any consultation process, and which was developed under land grabbing phenomena, I think preventing the development of another wind power project that would cover 1/3 of the total lands communities of the community, it is a very substantial change. And of course, if we look at the litigation we have now in France against this very large player in energy sector, EDF, Électricité de France, we also have the opportunity to advocate with this case before the decision makers that are currently discussing the possibility of having an European mandatory on human rights due diligence. So we have been able to address different problems with a single case, that of course we don't rely on only the legal results we might have, but rather the political movement and force we can engage in and create in order to tackle the way this law created by private actors and that only benefits the creation of wealth can be also used in order to counterback these violations and these structural problems that have created and that affect the most discriminated, excluded sectors, not only in Mexico, but also in Brazil, in South Africa, anywhere in the global south. So I think, of course, what Professor Pistor and Johan point out are very relevant, because it gives us returns us as lawyers to the very concrete system that we are facing, but that shouldn't be something for be discouraged, but rather to think precisely like what you were saying, how we use this law in a way that is critical but also creative. I also believe we have this advantage to counterback what has been happening so far.
Thank you, Guillermo. Katharina, I have two questions. So, does the legal order as it is necessarily and continuously create wealth, or do you see? So again, a bit, where do you see how would law have to change? I think you're also talking at some point about reflexivity, and you try to draw a bit on Menke. Maybe you can explain that. How would you see that law could structure society and relationships in a different way?
Well, I think 2 points first. First of all, just back to Guillermo, I think he's absolutely right that you use the tools that you have to fight the battles that you have to fight. And given how much we all depend on legal ordering, horizontal ordering, vertical ordering, we are wrestling inside the law. And I also close my book on the notion that the worst thing that might happen is that the law loses its authority, its legitimacy in the eyes of many, because we don't have many alternatives, right? We go back to the battlefield. It can be violence, or everybody withdraws to their own inner self, to their own little communities or individuals. But once we want to scale up and organize our society's laws, is essential. So I still have hope, and I also don't think that it's inevitable that law is used in such large parts to code private wealth. But I think we have made certain moves along the evolution of the legal systems, which don't have to stay. This is not rocket science. This is not cast in stone, right? We can push, and I think part of what's happening now with human rights organizations coming back is trying to push the law into a different direction. The question, of course, at some level is who has the greater resources to fight these battles in the long term. And that depends a lot on how the legal system is organized, how much entry points it gives to different people to use it. So I think of the legal system really as a way of harnessing our consolidated power of coercion, and we have consolidated the power of coercion mostly at the state level. The question is, when we have consolidated it, what is the institutional system that we have thrown around this, and who has access to that system? Now, just a little detour to Christoph Menke and his notion of subjective rights, about which Max Weber also has written, over a century ago. Those who can most powerfully rely on this notion that they have some fundamental rights that can also challenge existing new forms of legal ordering have a better chance, let's say, of winning that than others. And so resources matter a lot. And I think the fact that those who have resources have been able to push also the legal system, the interpretation of certain norms in one direction, is not such a surprise. What is important is to push back and to find new ways to both incorporate into the interpretation of law through legislative intervention or through constitutional norms a broader sense of justice and norms, rather than buy into very simplified frameworks that very often come from capital, right? We need more liquidity, we need greater legal certainty, we need more property rights protection, everything else will be fine. And I think we have all reached a point, and even many judges have reached the point where they realize that actually not everything will be fine. So there are, I think, multiple fronts to push back. I'm not sure I will, embrace Christoph Menke's idea about having more temporal rights and shifting them. But I think what we also have to be aware of is that these the notion of subjective rights that shall not be impeded by any broader social norms and obligations is something that we have to deal with in a more careful fashion. I don't want to throw this out, because I think for human rights is also important to have some clear notion of the individual and the individual rights to its own self-authorship. But at the same time, I think we also have to bring more ideas of what you call reflexivity, other regarding principles into the interpretation of law, and at all levels. It also has to go into corporate law. Even in this country, in the United States, people are talking again about things like co-determination, public interest or public benefit corporations, and ideas of broadening the corporate purpose. So it's slow moving, but it's not impossible. And I think that's what we just have to continue to do to fight these battles. I don't think we have many other options.
We will have now our last question that I will have for Johan, and then we'll have the opportunity to have questions from the audience. So please, audience, get ready to post all your questions to our wonderful panelists. And I want to stay on this idea of how rights probably need to be more reflexive, in the sense that every individual right also needs to be somehow seen and constructed in relation to the rights of others. I really like this idea, and I've been wondering, if you think, for example, about the developments, Johan, that you have already started to talk about, so let's say about the Shell decision of the Dutch court of last week, where they say that actually a company like Shell has the obligation to reduce its carbon emission by, I don't know, a given point in time. And so which means that it is that the corporation has more to do than profit maximization and generation. Also, I think something that we've here in Germany are currently struggling a lot about is to introduce a supply chain law that introduces a mandatory human rights due diligence obligations to companies, which means that they actually do have to consider the human rights impacts of ideally their whole value chain. Now, of course, in the legislative process, this has been cut down to some extent. But again, it's still with regards to their suppliers. And that also means that if that law hopefully is being voted into force, voted for next week in Parliament, that would mean there are new directors' duties that are not primarily to simply maximize the economic gain through the corporation, but actually to consider the impact, the human rights impact of others. So Johan, what do you say to that? So, and what do you think about the state power? Because for example, this advocacy for the supply chain law classically looks at the state as the actor that will regulate, or the European Union to regulate this field of law. So, I think you just said also before me that you're sometimes a bit skeptical about the role of states, and probably explain that a bit.
Yeah, thanks. I'm trying to be short. I think, the role of law was mentioned already, and I think we all here agree that law has always two sides to it, and that law can politicize, it also can depoliticize. It can be emancipatory, it has an emancipatory potential, but at the same time, the law can also be used by those in power. So law, I think, the form of law has necessarily both sides. When it comes to state power, I think I just want to maybe make one argument that when we talk about state power, we need to realize that not all states are the same before the law and before capital, so to speak. While the US or the UK or the European Union may have the power to change important aspects of the legal system on a global scale. For example, the legal infrastructure of financial markets. They have done so to a certain extent. This is not true for most other countries and constituencies in the world, especially in particular from the global south. And let's take Argentina as an example. Argentina was very much hustled into default in 2014, and Argentina couldn't do much about it. And therefore, I think it's not enough to involve national parliaments, in particular in powerful countries in the West, in the making of these rules, of these global rules, because they have global reach, right? Because we need to find some other way of articulating those needs and those voices which are not heard in these constituencies. That's it.
Thank you. So, we are now entering into the discussion round and questions from the audience. So here's the first question. I don't exactly know to whom it is going, so I think whoever wants to speak to that. The question is, are states enabling corporate power and thereby keeping it, or is the state captured in the sense that it is deprived of its power and taken over by corporations? Maybe Katharina. I think this refers to this, whole debate of what is it, and I think it's an interesting question because, is it really corporate capture? That's also actually something that I'm sometimes wondering about. Is it not that the state gives it? No.
Well, it's both. When you go back to the rise of the first major global commercial corporations, the East Indian companies, the English and the Dutch East Indian companies, these were joint ventures between the crown and the merchants, or between the general estates, who were also the merchants. So this was private and public power combined. And then over time, legislatures have basically carved out the rules that allow private parties to set up their own corporations without the state necessarily being part of it. So they have created a space of autonomy that private parties can use for their own organizations, for their own actions, for their own activities in the economy, etc. And that space has enlarged over time. So I always start with my students when I teach corporations. I give them the New York Statute for Corporations from 1811. That's 210 years ago. It's not that long ago. It says 5 persons only in manufacturing of textiles and other things. It says 20 years. You have a sunset provision after 20 years, and it says you can't ever have more than $100,000 in capital. So they realized that they were creating a Frankenstein monster, if you want. Of course, these rules were taken out quickly because other states started to enact more friendly corporate statutes for corporations, which then migrated to those states. But there were states that did this. New Jersey did this, Delaware did this, other states, North Dakota, other states did that, especially Delaware, of course, in this country. So the competition of rule makers has basically created a space for private corporations that they have used to enlarge their own power, their own influence, to pick and choose where they want to go and what they want to do. But it never happens to this day without the helping hand of a state. So the state might not no longer be the ultimate creator, but there's always aiding and abetting going on by some public agency.
Guillermo, what is your opinion about this? Do you find is this concept of corporate capture, is it more enabling or is it more disabling actually? Because if you believe the state is already captured, then what do we do then?
Well, it is a difficult question, but at least for us as organization, as human rights organization, and for a larger network of NGOs, we believe, of course, that a state is enabling or are enabling economic profit, but we have been pushing for this idea of corporate capture in order to provide us with alternatives. So we say a state is captured so we can push for the idea of how we can recapture a state for benefiting the people, for providing opportunities to everyone, to securing the enjoyment of human rights. But of course, we have to acknowledge that it is difficult to address this idea of the state as only like a passive actor in this whole set of economic laws that give basically the ground to private actors to accumulate capital. But one thing that we have clear is that even though it has been like a commonplace to know or to think that states now are deregulating and opening like their sphere to leave private actors to actually create and enforce law, there is still a need for them to for these private actors to have the state, and I believe Professor Pistor and maybe Johan at some extent might agree with that a state is still important. I remember Saskia Sassen highlights that since states have this enforceability and the military power, they are still relevant. And we also believe that states are still relevant because they have the ability to and the power to retain the advance of private actors capturing some spaces of decision-making or public decision-making, whether it is at the legislative branch, at the administrative branch, or the judicial branch. And yeah, I think we could adhere to the idea of corporate state capture, but not necessarily in a way to prevent us from doing something, but rather as the ground for battling in the spaces we need to battle in order to counter back those trends.
Thank you, Guillermo. So something that we have, which is we have not talked about today yet, but that is actually sort of in the room, of course, is Marxist theories. And so, to what degree can the Marxist concept of base and superstructure help us understand our current legal system. Maybe Johan, you have some thoughts on this.
Well,
as a legal theorist.
I consider myself more like a legal pluralist, so I would say that there was law before capitalism and hopefully there will be law after capitalism, which also means that while I think that that a materialist view on the form of law has a huge explanatory value for law and capitalism, I think it does not tell the whole story, and I think Katharina Pistor extensively comments on this in her book. And it does not tell the whole story because it, from legal pluralist perspective, does not see, for example, the law which exists, which is not capitalist right now, and we have law that exists which is not capitalist. We have legal traditions which are not capitalist. Think of the Allmende, for example, in Germany, and think of property law, which is much more diverse historically than in its current shape. So while I'm sympathetic to use the materialist view or a Pashokwanian view maybe to explain certain developments in capitalist law, I think we should not tell the story the way that the legal form of capitalist law is all there is to law.
Thank you. Katharina, do you have anything to add? Any thoughts on Marxists, on the use or on how helpful those are?
Yeah, I mean, I think Marx has had major insights in his own days. I also quote some minor things by him when he basically unpacks the rotating, no, the Crédit Mobilier in France. I just had to think for a moment, and he just really understands, looks right through what's happening in this scheme, which is not so much different from some of the structured finance schemes that we see today. So I think there's much to admire about Marx. And I think also you can interpret him in different ways. Sort of the simple idea of basis and superstructure could also be reinterpreted if you read more around him. But if we just take that metaphor, my argument would then be somewhat different than what sort of the general interpretation of Marx is, that he says sort of the means of production, or that sort of the allocation of the means of production is the foundations, and the legal system is the superstructure. The bourgeoisie gains power and then controls that superstructure. I think it's a bit more complex than that. And I would first start, of course, that with saying that the means of production are allocated through law. So law is at the very, very foundation of everything, because you allocate the rights, you allocate better rights to some than to others. They can use the rights to place their stuff into the production process, and then also extend their rights to extract from what they want to get out of it. But we also have to recognize that Marx wrote in the 19th century, during the first period of industrialization, that both the law and industrialization and capitalism have evolved ever since. So I think there's still extraction going on, but it's no longer just, and in some parts not even mostly, the extraction of surplus from labor, but it's this extraction of surplus from society. So, when we go back to the financial system that Johan was talking about, then I think the repeat bailouts by central banks, the liquidity provisioning, and etc., can be characterized as a socialization of losses that the financial system had produced. So if you want to, you can press things back into a Marxist perspective. I did not do this in my book. I also did not engage a lot directly with the neo-Marxist literature, because I just did not want to necessarily adopt that narrow framing, but sort of describe how I saw the system evolve. But lots of elements that Marx identified in his own time could be identified, but maybe in a slightly morphed fashion today when we take the system apart. Just a final point on Johan's sort of legal pluralism and not all law is capitalist law. That's true, but I think it's important to realize that this body of private law that exists out there, and that exists in ways that can't be fully captured by the arguments about regulation and deregulation, is a huge empowerment of private actors to organize their own lives. And resources matter to do so. So again, I don't think it's an accident of history that it happened that the most resourceful people have been able to mobilize the law to their own ends. Again, I think for me, the legal system is the institutionalization of our consolidated means of coercion, and how we organize this and how much leeway some people have and how many obligations they might have to others is part of this institutionalization process, which changes over time. And so I don't want to be entirely hopeless. I just want to be sufficiently realist to say, the powers that be, the powers that have the resources, are difficult to battle with the means that we currently have.
I want to now come to a concept that also is, I think, relevant for all of us in our work, and that is the concept of equality before the law. Right, that is one, and I think Johan and we've been discussing that last summer. I think I started when I was grappling a bit also with the potential, right? So on one hand, you can say from a critical perspective, equality before the law means it's a fiction because it doesn't exist. And I think, Katharina, you also point out, right? So people that are resourceful, they have more, usually the law deals a better hand to them. But, Johan, wouldn't you say that there can also be, isn't there also a chance behind this fiction?
Well, yes and no. I think if we look at the real world, I don't see much chance. But I have this quote in mind of Annelies Wright, I think, when she says that whatever the means or whatever the original plan by private entities, by states, by creating law was, this might change over time, and this original plan in the law creation can also change through social pressure and can be revolutionized from within. I think this has to do with how the law works. That's the same structure, I think, that allows corporate power to take the law and shape it according to their will, also allows for interventions from the other side. But by this I don't mean that we should turn a blind eye to resources. I think that's really important, and this is actually the core question for an institution like the ECCHR, I think, how to counter these imbalances in resources through law. And I think it's an open question, but I think we can see, like, if you bring a case to a court, you see glimpses of hope in when you make a legal argument and the judge is not only looking at power when he reads this argument, but there's always some sort of, I don't know how to describe it, but this argument has is not only an expression of power. It's always more, and this is what the law is about, I think.
Yeah. I think we had this conversation a while ago when I was trying to describe what I believed happened when we helped Saida Khatun from Pakistan and Mohammed Jabir to bring their case to the court of Dortmund, right? And obviously, the fact that they can, with all the resources that need to be provided and organized, sort of, but the fact that by law they can go to Dortmund and sue Kik and force Kik to hire, I hope very expensive lawyers to defend their case, and that they can force 3 of those lawyers to show up in court and sit there, and they can't, like the CEO didn't come, so he could avoid this, but these lawyers couldn't. And see this woman sit there who lost her son, no? And I thought that is, there is something powerful in this, although it's a complete fiction that they would be equal before that judge, right? They're completely not equal. And again, it's this fiction that gave them the opportunity to do so and somehow to play out those roles. And and I think it's Johan, it's a really interesting observation, and also it fits with what Guillermo was talking about, right? So how do we mobilize resources that are not necessarily capital intensive, but other resources, no? And how do we help in this organizing process? I think also remember, so we had Saida and the others travel through Germany, speak about this, sort of really gained, so that this whole case and their claim gained attention, that they moved out of being, the helpless victims that you usually see when you saw pictures of the Rana Plaza accident, for example, right? So that just complete devastation. Yes, so very interesting. I think we have another question now from the audience, which is what other tools than law could be used to curb the economic inequality that is constituted or upheld by law? Who of our panelists wants to speak to that? It's a big question, obviously.
I'm happy to take. I'm happy to take a step. So, many of the things I'll say will somehow relate to law again. But I think we could use the resources that we have in governing, our collective means of coercion, but also in making bets on our collective future. We could use them in a much more equal fashion. And I think some of this has also happened during the COVID crisis. So when central banks bail out the banks, they're basically making a bet on our collective future in a way. And if they make the bet not only for the banks, but also for us by giving households money, it's an important support during this crisis. So redistribution is, of course, the big word. If you don't do the pre-distribution that I talk about in my book, thinking about how you could use the legal system to allocate the priority rights, the durability, universality more equally. But you can also say ex post facto if you haven't managed to do so. You do it through taxes, you do it through redistribution, social welfare system, unemployment insurance, et cetera, et cetera. But you also do it in a crisis by making sure that people have access to resources and that maybe some of the obligations that they have taken on in the past, which they can no longer sustain, debt in particular, might be forgiven or might be reorganized to give them another lifeline to start again. So I think these are mostly the two big parts of the equation. Is of what do you do up front, how much private wealth can be created without anybody looking closer. And my core argument in the book was to say that private wealth creation happens through law. And that's what nobody talked about. Everybody talks about that these are the private markets and the private entrepreneurs. It happens because they can use a corporation. It happens because they can rely on the state enforcing their rights. So when we want to collectively take countermeasures, this typically works through the institutions that we also have created. So in that sense, it's law-like, right? But it's just a different channel through the legal system that we are mobilizing: tax legislation, tax enforcement, social welfare, and the other elements I mentioned. And that's within states. Of course, on a global level, we have to think further, right? Sort of what is the distribution of wealth, not only within countries, but also between countries.
So another thing that you, Katharina, are also writing about your book, in your book, but one thing that is also being discussed, I know in debates here in Germany, when it's about how can we counter what we there call corporate power or Konzernmacht. What role can antitrust law play in order for the state to break up companies so that they do not become too powerful or too big to fail, and so on? What do you think?
So I think antitrust law is quite important. And also remember, it came about in the United States in the 1890s for a reason, because these big trusts had actually controlled markets in such a way that they could set prices for others. And so a law was enacted, a federal law, to allow the breakup of companies, certainly fines, and also give private parties the power to sue them as competitors. Now, we have had several examples of breakups of major companies, and there's an ongoing debate of how effective this has been in the long term. Nonetheless, I think if you break up AT&T, even if the belts come back and recapture some of the market, it's still been an important signal to the rest of the economy that actually this will not go unchecked. And I think the current debates about possibly breaking up the big tech companies already have probably a somewhat chilling impact on how much more consolidation of other companies that what they want to do by just gobbling them up, merging with them to prevent any competitors coming their way. So I think it's important. I also want to point out that it's, of course, not always the complete solution. So when the United States enacted the Antitrust Act, the Sherman Act in 1890, shortly afterwards, New Jersey basically allowed finally corporations to hold shares in other corporations, so that the trusts could all come to New Jersey, reincorporate themselves, and create the same structures just inside what was now a corporate family, and thereby avoid the antitrust survey. And so what I'm saying is basically we have to make sure that when we take a particular tool, that we also realize what the next move in the private sector will be, using again the legal system, but a different part of the legal system to counteract it.
So we are slowly coming to a close for our discussion today. And so I want to have the last question, where I'm actually very interested for all of your panelists' opinion. And that is, I think, it's a question that by which we can also summarize to some extent our discussion. No? So we have been talking about, so we have seen and heard Katharina's brilliant ideas and thoughts about how law is sort of helping and constituting corporate power and wealth, and thereby creating inequality. And we've also been talking about the different methods that different actors take to counter that, right? So using litigation, using what is there, looking in possibilities of creating new norms. And so what is the good question that we now have is, what ways do you see to help politicize law and build movements, as it is a field that requires so much expertise and understanding, law in itself and in the litigation. So I think each of you can answer now in 2 minutes to this very big question. Johan, do you want to start?
I think one thing is really important to me is that if we talk about expertise and whether things are complicated, this should, first of all, law is not that complicated, I think. And it's also like some sort of technique of governance to say, for example, financial law is so complicated that nobody understands it. No, that's not the case. I think and another point I want to make is we all have an opinion on atomic energy, on nuclear energy, and we all don't know how nuclear energy really works, right? So lack of expertise, even if we have lack of expertise, does not prevent us from forming an informed political opinion on these topics. And I think we should not be afraid, and we should not leave people off the hook by just saying, when they tell us, oh, it's too complicated and we really need to enforce these laws, otherwise everything goes to hell or something. We should make our own opinion. I think that's possible. Law is not that complicated.
Thank you, yes. Guillermo, what's your take? 2 minutes.
Well, I think that it should be rather the other way around. It's not necessarily, or rather it is naive to think that law is the ultimate goal that social movements embrace and want to change, but rather one of the expressions of their political demands. So I would say that the most important question here should be how we are able to sustain, either as human rights NGOs or as activists or as academic scholars, how we can sustain over time the power, the energy of social movements in order not only to change law, but also the way law is being applied, or how the government is behaving in light of many of the problems that we face as a society. And I think that law, of course, it is an important element, because as Professor Pistor was mentioning, one of the most challenging issues with respect to social movements and litigation is time. So, but I think law, and specifically human rights law, can be a very powerful tool to sustain social movements over time, to translate into legal responsibilities for both public and private actors. But that shouldn't be the ultimate goal for social movements, but rather how they can channel in an adequate way the energy, the hope, the expectations, the political demands they have, not only before the court, but also before other political spaces. Either it is at the European Parliament or before the authorities in charge of implementing or taking decisions over a project, a mining, a dam, whatever problem it is in the middle, including how we can some sort of stop the advancing of these private laws or public laws that are providing the ground for creating and accumulating wealth over time. So I would say that that should be like the most important question for all of us to ask, rather to think on how the law can like fuel movements, but instead how social movements are fueled by the idea of political change, including the way law is being created or applied.
Thank you. Katharina.
Yeah, I was just thinking of two quotes by two colleagues. One is my former colleague, Jeremy Waldron, who said, actually, about 20 years ago, he made the point that the rule of law is an essentially contested concept. So we're always contesting what this really means, and it should be contested, but it's also contested in a certain form, thinking about what the law is and using certain arguments and not others. So to some extent, the fiction that we actually are equal before the law, that we all can argue about legal matters in a way that is not utterly politicized, I think is essential for keeping the legitimacy of legal governance alive. And the second quote is by Akos Ronatas, who worked with me on a project years ago. And he said, law is the differential relation to power. So it's not identical with power, it's the differential relation to power. Having access to the law is one expression of power and one way to mobilize, as Guillermo said, but it's not the only way. So I think we have to be aware of the role of power in the legal system, but we also have to make sure that we can curtail power, whether it's from corporations or individuals, even from social movements, that we have some playing field within which we can contest the concepts of the law within the law.
Thank you. Thanks to all of you for joining in this discussion. I think, yeah, I liked very much also, Johan, what you said to the end, that you know, we shouldn't also, and I guess especially as human rights lawyers, we shouldn't be intimidated by those corporate laws, by financial law, as you said. And I think we should be also embracing this and using it as a tool. I think, Guillermo, that's what you've very powerfully described also, that we shouldn't only put all our hopes on law, but we should really use it in a way that is beneficial to those that are underprivileged and marginalized. So thank you for the discussion. Thank you, Katharina, for your book. Again, as I said, it's very good to have someone, a very academic and coming from corporate law, describe the problems that we all face. So thank you, and showing some of the solutions. I now also want to take the time and to announce the next session in this series, which is on June 22nd, again at 6 p.m. Berlin time. And this time we will discuss climate change and environmental degradation and human rights. So thank you all for your time.